mean should be based on a level that I wish that I'm really glad that I opened this court case, and also I'm really glad that there wouldn't be too many sanctions implemented on the other party. So it is the classical civil law information. But for what kind of an environment we talk about this? So the civil law was issued at the end of 19th century, and at that environment this concept was developed. So if we adapt it to this current environment that we live in, with its own conditions, can we really implement this rule like it was developed for as its first stages? Can we apply it or not? In the past, when it comes to punitive damages or immaterial damages, in the past it was the Tortures Act, for instance, it could be the slandering or the oral verbal insult on the newspapers or else on the books, for instance. So how many people would be buying this book? How many people would be reading this newspaper? Based on that, we would be actually determining the amount of the damages. But it's not like that anymore. So writing a tweet, sending a message on Twitter, what does it mean? It's not only valid for Turkey, it's not only valid for your country, or it's not only peculiar to your region. Everyone on your district, everyone on your country, even the continents, all the world, all the countries in the world. So this Tortures Act effect area is much wider. For that reason, legal people should also be producing solutions based on this new reality. So, this is very simple maybe, but are we still on the right path when we evaluate these immaterial damages act? So should we be thinking about this enrichment prohibition or not? Ban on enrichment or not? What should we do? Or unjust enrichment? So this is related to civil law and also code of obligations. This is valid for all kinds of areas of the judicial areas. So in these 3 days of Congress, we will be discussing these topics with 40 academics, and we will be listening to great presentations from very valuable speakers, and we can say whether, as of this moment, we are really applying the correct solutions to these specific problems, and we will find a chance, an opportunity to evaluate it all together. As I've stated beforehand, this is an important Congress, and I'd like to extend my gratitude to everyone who has exerted their effort for the organization of this Congress, all the institutions, all the names, and many assistant researchers and our lecturers. Thank you very much for what you have done. Thank you so much.
Now we would like to thank the Rector of Turkish-German University, Professor Dr. Halil Hakkanat. Now I would like to invite Turkey Human Rights and Equality Authority President, Professor Dr. Muammer Kılıç. The floor is yours for the plenary speech. Distinguished President of the Authority of the Protection of Personal Data, distinguished rectors, distinguished deans, distinguished audience, and distinguished spectators, I would like to salute you all with respect and love. And I would like to thank to the President and the rectors for this kind invitation. The personal data protection is a basic human right and freedom, and we need to handle this topic from this perspective. But beforehand, let me tell you that, as stated by the rector a minute ago, we are now in an information era, and when we have this matter from this perspective, this story started, along with Max Weber, the world has lost its charm and magic. Its Weberian projection is now a reality in the most dramatic manner. This information era, social media era, digital era, we are all experiencing that very intensively. For this reason, no matter where you are, if you do have the devices and the connection, you might do something which can affect the rest of the world. You can breach the fundamental rights and freedoms of a person. You do have that power to do so. For this reason, losing that magic had an effect of a snowball, and the era has become a network era. And this network society, as you all know, was conceptualized in the last part of the 20th century, and I think it's expressing the digital era well and this digital transformation well. This network society, Ulhi Pek's risk society, I would like to make a reference to that. This is a new risk situation, a risk map. It's resulting in a new risk map. And as the President of Turkey Human Rights and Equality Authority, our main focus areas are the human rights, and this is overlapping with our corporate responsibility. Let me tell you that the risk is growing day by day. Network society, if I may say, is an automized era, and the freedoms have been diversified, the rights categories have been diversified, and this is an interesting coincidence, in my opinion. On one hand, the expansion in the rights and freedoms, their personal realization from individual identities, collective identities. On the other hand, people are under siege in this automized world. We might express this in other concepts as well, like the techno-capitalism is another concept that we have been using. It's a revolution in onto-epistemologic perspective, a new human description. I call it as transhumanistic existence form, ontorobotic existence mode. I wrote an article about artificial intelligence. This is a new level of representation. It's a new level of existence. In a way, it's more than realizing yourself, a new form of existence with the technologies, and a form which can substitute himself. It's necessary to utter that. And Herbert Marcus, I would like to make a reference to him as well. Technological rationality is how he calls it. And this technological rationality means that the person, on the basis of the intelligence, continues to survive, to exist, and it's also limiting the human being at the same time. Months ago, I watched an episode called A Social Dilemma. I don't know whether you watched it or not. In terms of personal data, is about the basic fundamentals of the existence of that person. And in this documentary, not a series, in this documentary, people are left helpless, how they are manipulated by their personal data, how they are directed to certain actions and decisions. This new existential situation, which is called as ontotechnology, we might say that people's freedom zones are facing more threats as the days go by. And interestingly, data, acquired data, and it's an, we can't avoid them anymore in this era. And this personal data protection law is not only about our country, it's also a matter of international agenda. And we might say that they provide a limited safety zone for people, but there's data capitalism zone was born, and the data pollution has become our reality. And from the perspective of data capitalism, it has become a meta zone. The information is being taken, the personal data has been robbed, and they become a meta, and they're being used in different sectors. Therefore, this is against the fundamental rights and freedoms of a human being, and we need to handle the matter from this perspective. Here, especially in Turkey, the Authority of Turkey Human Rights and Equality, we do have 3 focus points, which are as following. The material and unmaterial elements of a human being should be protected, and they are directly related to the basic rights of human being. And the breaches against discrimination, we are creating a safety mechanism, and we do have the authority to have administrative sanction, to apply administrative sanction, and the relation between the ban on discrimination is directly related to this matter. Therefore, the breach of this data is related to the ban against discrimination, which has been stated in the code number 6157. They are directly correlated. Here, the physical characteristics, the fingerprint, the education level, ID information, ethnical root, the profession, the religion, all kind of this information should be kept, should be regulated within the law on ban against discrimination, and the breaches should be avoided in that regard. So they are, as I stated earlier, directly correlated. And as you all know, in 2010, 22nd, there has been an amendment in the 22nd article of our Constitution. The scope of the privacy of personal life, we need to understand that the right to protect personal data is a new area of right, and it's independent area of human rights, and this is also being discussed. As I stated earlier, the autonomy, individual autonomy, the value of the human being and the existential value of human being are breached by this approach, because the value of a human from the perspective of human rights philosophy, it's about the dignity of a human being. And the main purpose here, within the framework of the protection of personal data, the ontological value, the human dignity have to be protected. And this, the protection of the human dignity is about self-realization, protection of the areas of self-realization. And it's about the philosophy of the protection of the value of a human being. And if we look at the matter from this perspective, within the scope of the protection of personal data and the rights of a human being, all the arrangements are aiming at protection of human dignity and integrity. And I would like to take this opportunity to thank the President, and also I would like to thank you for this kind invitation, and I would like to thank the rectors of both universities for hosting this event. My deep respects to you all.
Konuşmaları için Türkiye İnsan Hakları ve Eşitlik Kurumu Başkanı Sayın Profesör
would like to thank Professor Dr. Muharrem Kılıç for their speeches, and I'd like to invite Professor Dr. Faruk Bilir, the head of the Institution of Protection of Personal Data. The floor is yours.
Sayın rektörlerim,
esteemed rectors and esteemed head of the Human Rights and Equality Institution, and esteemed head of the TRNC Data Protection Institution, esteemed academicians, esteemed guests, dear participants, dear audience, I'd like to salute you all with my respect. Welcome to the first International Congress on Personal Data Protection. I'd like to thank two universities' efforts for organizing this event, the personnel of our institution and also the representatives of these two universities. Thank you so much once again for your efforts. As you all know, in the change amendments of the Constitution, 20th article of Constitution was added a new paragraph in 2016, and also new coverage was added for personal data, privacy, and right now they are under the guarantee and protection of Constitution, and right to protect personal data is one of the laws in one of the rights supported with Constitution, and personal data related legal matters are going to be arranged with law and codes, and first and foremost, personal data protection law was enacted. So in this respect, this code, this law is like the main actor for the actions and efforts for personal data protection. So the processing of the personal data could be under discipline and order. So this law is not a prohibiting law, but on the contrary, it is a law which is adjusting and organizing. So this law is not preventing personal data processing, but it paves the way for legal processing of the personal data. So according to this code, personal data could be processed, but during this processing, there are certain principles and conditions that must be obeyed. Personal data has a very long journey in our country, and after this main constitutional amendment, we can see this as a gaining, actually. After the realization of this act, right now we can see ourselves as the representatives and responsible persons of data protection, because it is very much related to the security and insurance of persons' privacy and autonomy. So personal data is something which must be protected based on these obligations, and we have already initiated our works with the establishment of this institution. This code has brought autonomy, control, and authority rights of the controller, owner of the right, and also at the same time institutions can develop their institutional capacity and respect in the international arena by protecting the data of their citizens. Our law, our code does not see these codes, this data as a commodity, and this is something to be protected. This is a value according to our code. Protection of personal data, privacy of the person, dignity of the person, these are the same according to our law, because protection of the data means as well the protection of privacy. Unless there is something hide, there is no reason for concerns and anxiety. Actually, this understanding is conflicting with the private life, and it is not in line and concordance with the right to have a private life. It should not be evaluated like this. Personal data protection is something which is related to the protection of some secrets or confidential information, but the privacy is something else. It is not something blessing or a choice. This is an area of freedom. So personal data protection is not the main goal, but it's an instrument, because thanks to personal data protection, privacy, dignity, honor could be facilitated. At the very center of the personal data protection, there lies the protection of the humans themselves. For that reason, it must be considered in every levels of our lives. So, of course, personal data is not something given to the owners of the people in a limitless way. In order to have some competition for the companies, for instance, or institutions, it is indispensable that this personal data would be processed. In the past, we were maybe forgetting, but right now, to forget is something very rare. But in the past, we were saying our friends, do not forget me at all. But right now, to be forgotten is something very rare, but remembering all the time is very ordinary. And it might lead to certain types of discrimination if people are described in some stereotypes with their personal data. Data-driven economy, personal data protection must be also dealt with very closely. And there is this balance between this data-driven economy and personal data protection. Personal data protection and privacy, and also, as I've said it before, and that balance must be paid attention. Esteemed participants, as you all know, there is this IoT, artificial intelligence, implementations, and also data processing of the smart devices. These are some common things that we see all the time. And we might have certain question marks on our minds when it comes to personal data protection and artificial intelligence, because the rationale of artificial intelligence is to use huge amount of data and come up with meaningful solutions. But when it comes to the data processing of the artificial intelligence, I think people should also be having a right to object for the processing of their own data by some other artificial intelligence devices. Each and every day, data processing activities are increasing, and honesty and transparency and accountability must be at the core of everything that is related to data. In today's world, we know that society is data-driven. Especially after the pandemic, including our country, many countries in the world, digitalization has gained more speed, and digitalization should not be evaluated without touching personal data protection. Activities that have been held by our institutions and support for personal data protection will be very beneficial for the future of our country. This is how I believe. Of course, the use of technology for the sake of humanity is much more important than the developments of the technologies itself. And our country can't be out of the scope of these developments at all. Our country is taking very robust steps into future, and again in the personal data protection, our country has taken too many concrete steps. But the best implementation of a law is to interpret the law in the best way. So in order to settle this implementation, we have to have innovative and creative approaches, and if it is needed, we should be having some updates and legal adjustments on the personal data protection are a part of the steps that have been taken by our nation. Again, in this framework, our country supports the data-driven economies and technologies, and also in the personal data protection, our country, our government have made many reforms in the presidential 11th Development Action Plan, in the Justice Action Plan document, and in the Economic Reform Action Plan. The law numbered 6698 has become harmonized with the European Union legislation, so it's going to be harmonized. So GDPR and personal data protection law will be harmonized. This is what we are working on, and we have already finalized our works in this respect as institution. Esteemed guests, I'd like to briefly mention certain activities that we have been conducting for a while. Certification mechanisms for personal data protection are going to be initiated. A new document will be published with respect to these, and also some other institutions like Radio Television Supreme Board. We have undersigned a memorandum of collaboration, a new protocol for cooperation. These documents have been prepared, and also awareness project for personal data protection will be initiated in 15 different cities. Information and awareness campaign is going to be initiated, as I've stated, and also on the individual and institutional levels in order to raise more awareness for personal data protection, we have already prepared some guidelines and also flyers, and right to be forgotten should be only evaluated on the research engines side, and the ones that we know as truth about actually the wrong things and the things which must be known with respect to personal data protection should be very soon shared with our nation. And there is this cartoon, Rafadan Tayfa, in TRT Child TV channel. And those TV channels characters have already been used for raising awareness on the children's side. And we have also had some data protection projects on a voluntary basis. And we will have the second phase of this project with the engineering faculties of our universities. And I'd like to share some statistical information with our institution's events. Our institution has been given certain tasks in line with the law. So as of the first date that we started our works, January 12, 2017, including international applications, we received 11,000 applications, and 8,800 of them have been finalized. And we have also given 6,777 comments and interpretation. And there were many data breaches notified to us, and those notifications are also on our website. 4 commitments have been also accepted by our institution. Esteemed guests, our institution is a member to International Privacy Assembly, and we are an accredited member. In the 30th General Assembly of the institution, we became a member, and in 2022, in the 44th General Assembly meeting, we have already sent our application for hosting the event in Istanbul, and by the way, it has been approved. So next year, our colleagues will be hosted in our country. Under the light of this information, once again, I'd like to welcome you all to the first International Congress on Personal Data Protection, and I wish this Congress will be very beneficial and fruitful for our countries. First and foremost, I'd like to thank Turkish German University and Istanbul University for bringing us together in this event, and academicians and all the participants. I'd like to thank you so much for your contributions. And again, German Federal Data Protection Committee head and German Hosting Data Protection Authority and Bulgarian Data Protection Authority head, and also TRNC Data Protection Institute head. I'd like to thank you very much for your contributions, and I wish a great Congress to all of you.
Thank you very much, Mr. President, Professor Dr. Faruk Bilir. Distinguished participants, we have completed the plenary session of our program. In the afternoon, we're going to start at 2:30. Thank you very much for your participation. And I hope that this is going to be fruitful for all.